IPR practitioners in India and abroad to this new form of IP and its potential. We are hopeful that our discussions today could also stimulate a brand owner's interest in expanding their brands into the virtual world to create new user experiences and value propositions to the end consumers. I'm moderating this session with my colleague, Mr. Devjyoti Sarkar, Managing Associate at the firm, who handles both contentious and non-contentious IPR matters, who will now introduce our distinguished panelists. Thank you.
Hi, everyone. Good morning, good evening. And so I will first begin by introducing Mr. Rajendra Mishra. And I think all of us are present also in our virtual avatars, as you can see on the screen. Mr. Mishra is the Executive Vice President and General Counsel at Indian Hotels Company Limited, and which is South Asia's largest hospitality-focused enterprise offering services under reputed brands such as Taj, Selections, Vivanta, The Gateway, Ginger, Expression, and Taj Sats. I think most of our Indian colleagues and some of our foreign delegates would also be aware of these brands. He's a seasoned business legal professional with over 24 years of experience. And during this period, he has served as an in-house legal counsel of several leading FMCG business houses like Unilever, Hindustan Unilever Limited, ITC Limited. And his experience spans across many sectors, including personal care, home care, tobacco, food, lifestyle retailing, aluminium, and the tire industry. He has extensive experience and expertise in litigation management, intellectual property management, competition law, corporate law, driving strategic business initiatives, and I might also add non-traditional trademarks. So his company happens to be the first in India to have secured an image trademark over its iconic Taj Palace Hotel in Bombay. Thank you, Mr. Mishra, for joining us today.
Thank you, Devjyoti.
Next, I come to Mr. Motohiro Katsumi from Japan. Mr. Katsumi commenced his career in intellectual property rights in the year 2002, and he has been with Aoyama and Partners Japan since 2006. With his extensive experience, Mr. Katsumi handles all aspects of trademark law and practice in Japan and in other countries. He also has expertise in availability searches, filing and prosecution of trademarks, and management of worldwide trademark portfolio. His practice also includes advising clients on enforcements and, of course, negotiations in trademark and unfair competition disputes. Thank you, Mr. Katsumi.
Thank you, Deb. I'm so honored to join this session.
Next on our panel is Ms. Michelle Shitola. She's a partner and a chair of Cantor Colburn US and is a part of the trademark and copyright practice. Michelle concentrates her practice on counseling, protecting, and enforcing trademarks, trade dress, copyright, and all other forms of related intellectual property rights, and also counsels clients in unfair competition, internet, advertising, and promotions law. She also assists clients in the development and exploitation of their trademark portfolios, including clearance of marks, prosecution of trademark applications before the USPTO, identifying important overseas jurisdiction and filing or coordinating with local councils for protection and enforcement of marks in those jurisdictions. Michelle develops strategies for the enforcement of her clients' IP rights, including preparing demand letters, negotiating settlement agreements, handling oppositions, and also cancellation proceedings before the TTAB. She also coordinates litigations with local councils across the world. Michelle also regularly handles UDRP proceedings and prosecutes and files copyright registrations and applications before the US Copyright Office under the US copyright law. She has also handled clients in several trademark due diligence matters, as well as drafts a wide range of intellectual property agreements, including assignments, licenses, trademark consent, and coexistence agreements. So welcome, Michelle.
Thank you very much. I'm excited to join this panel today.
Thank you. And our last panelist is Ellen. and she's from France, and she's commenced her career in IPR in 2005 after studies at CEIPI of Strasbourg in France. She's a French and European trademark and designs attorney, and she handles all aspects of trademarks and designs law in France and in other countries. Her expertise is focused on the management of trademarks and design portfolios, including availability searches, filing, prosecution of IP rights, pre-litigation, and litigation. So thank you, Ellen.
Thank you for inviting me.
So I think I'll now we'll begin our session with certain questions which we felt would perhaps help the audience in understanding about virtual trademarks. And I hand over the session now to my colleague Shruti.
So my first question is for Michelle and Ellen. How did virtual trademarks originate? And the connected question would be, has it become more relevant during the pandemic when consumers are spending more time on virtual platforms? Should we start with Michelle?
Yeah, I'd be happy to start this. I think virtual trademarks have been around a lot more than we recognize, because there's been such a proliferation in the past several years. But really, we've been seeing virtual trademarks. I think back to was 2008, excuse me, with Second Life. But even in the gaming industry, there's been virtual trademarks in games for quite some time. And I do think that it arises out of really a need for consumers or for brand owners to connect with their consumers on a different level in the virtual world.
I think when we discussed about this topic, this was way back in December.
Mm-hmm.
We hardly had about 2 such filings in the US. It was mostly Nike, and I think it was only Nike. I mean, and then now you see so many other filings.
Yeah, actually, all major brands across industries have been filing for virtual trademarks. I did a search recently of the USPTO, and I believe that there are something like 3,600 pending or registered marks featuring the term NFT, non-fungible token, which is really incredible when you think about this, just a sheer number. And again, it's across all brands. We're seeing it, clothing and footwear, celebrities, musicians are filing. You have, as you mentioned in the introduction, Walmart has filings for NFTs. Clinique, all kind of, it's amazing that brand owners seem to be embracing and this new area and really working to protect their brand in the virtual world.
Coming to Ellen.
Yeah, I agree with Michelle. The virtual world exists since a while with Second Life and The Sims in gaming, etc. And I think the pandemic is something which was a trigger and something like develop the need to connect the consumer and the companies when people were stuck at home and they need to interact, and the people and consumer companies was in need to have a connection. And I agree that with the thoughts of Michelle. And I think in Europe, the filing are not so, the rhythm is slow, slower than in the USPTO, but trademarks in Class 9 are filed, and we see that companies are interested more and more in this kind of application. And I think really the pandemic and the announcement of Facebook was something which rushed the things about this.
Yeah, Ellen, I think you're absolutely right with the pandemic speeding things along because, it virtual trademarks in the virtual world gives us the opportunity to connect when we were in isolation from one another. And I think that really drives, I think this is some place that we'd end up eventually. But I definitely think that this sped things up. The pandemic sped things up and brought us to where we are today and why we're having a panel.
Virtually forcing us to be there. Then we move to the next question now I have for Mr. Mishra. So who are the target consumers of such virtual goods and services according to you?
So first of all, thank you so much. It's a pleasure and an honor to be a part of such an erudite panel here. And my felicitations to you for organizing this webinar on a topic which is a very future-looking topic, right? And I would attempt to give a slightly different color to the discussion in the sense that I think while trademarks in the virtual world have been there for some time, as mentioned by Michelle and Ellen earlier, I think the real excitement is starting with the advent of metaverse. And that is in its initial stages where I think people are talking about it, where people are exploring possibilities. Today, looking into the future, a lot of people have come up with a lot of ideas. But this is an evolving topic, and as we go along, there will be more and more areas where the virtual world and metaverse in particular would extend to. With that, on the issue as to who would be the target consumers of virtual goods and services, I would say firstly, that the target group would pretty much be the same as that in the real world. Number one, if I have consumers who are, let's say, guests of the hospitality industry, that would again be the target, whether this is the real world we are talking about or the virtual world or the metaverse that one is talking. That having been said, I think we will need to then cut and slice from this universe to see at relevant points of time what would be the target audience or the target consumers. And I would think that at this point of time, while the world of target consumers could be niche, as time goes along, as technology develops, and as technology becomes cheaper, as gadgets become cheaper, this would become more widespread. And from niche, it would become a much more wider target consumer group that one would have. Again, as I said, you would have to cut and slice the entire universe. I would say that the first adopters of this would be Gen Z, the millennials, and people of the older generations would follow. Not all may come onto the bandwagon, but then I'm sure that over a period of time, those who are more familiar or more adaptable to technology would also join the bandwagon. And then you look at individual industries. If you look at specific industries, then you would arrive at your target audience as to who would be the target customers for which, for virtual goods and for virtual services. Look at the hospitality industry, for example, from which I come. And in the hospitality industry, let's say that somebody is about to marry, okay? And you would want to have an option of, let us say, 6 or 8 hotels where you could have your banquet function. The metaverse would enable you to actually shortlist 2 of these by not even visiting these properties, right? And therefore, your target audience would be those customers, those guests who would be willing to invest in this and be willing to participate in this. Similarly, for example, you could have, let's say, the business world, let's say virtual stores is contemplation. We already have a few of them on the metaverse, right? And as far as that group is concerned, again, the customers who are the regular purchasers of these products, they would be the target customers for these virtual goods and virtual services.
Thank you, sir. Thank you. Anybody wants to add anything to this? Okay, so then we'll move to the next one. Devdutt, you would like to take?
Yes, certainly. And I think I'll come to Mr. Katsumi next.
Yeah.
And Mr. Katsumi, there has been a lot of discussion on whether the existing niche classification, which we have for registration of trademarks, is sufficient to meet this new form of intellectual property, which is virtual trademark. So is there a need for a separate classification for virtual trademarks? And also to add to that, has any of the laws, the statutes, caught up with this new form of IP in the specific jurisdictions we are representing today?
Yeah, thank you. Under the current classification, niche classification, digital images or music files, electronic artist work shall be classified in class 9 if downloadable. And the non-downloadable the digital images shall be classified 41. Non-downloadable software should be classified in class 42 under the current classification. As you know, the expert committee meetings of niche classification will be held in Geneva next week. I will be attending that as an observer of JPA. However, I checked the agenda and I contacted JPO, who will be attending the meetings, but there's to be no discussion about the virtual trademark classification, unfortunately. However, some proposals about non-fungible tokens will be proposed by the French IPO and USPTO. But French IPO's proposal, non-fungible tokens bracket, NFTs bracket, it will be, in my opinion, it's unlikely that it will be unacceptable due to the unclearness. And the USPTO, the proposal is so specific. Downloadable music files authenticated by NFTs are very specific. It is acceptable. However, some IPOs do not support this proposal. This is because downloadable music files is already included in the list, alphabetical list. So they do not think it is highly necessary to add the new proposal. So I don't think the discussion will be facilitated by the meetings. So we should discuss more and to push the IPO to establish the new classification. And so currently, most of IPOs do not think new classification is necessary. But I was thinking about the new classification for virtual trademarks. I remembered the King's Cross Station in London. You know, there is a platform 9 3/4 in Harry Potter. So we need to discuss about the new class between 9 and 10. So after that, it made me realize the new classification. So and I think it is so quite old-fashioned to classify electronic products into class 9 and 41 or 42, depending on their downloadability. Downloadable one is class 9. That non-downloadable one is class 41 or 42. It's very old-fashioned. So my proposal is to integrate the one class, all electronic products in one class. So I hope so. Thank you.
Thank you, Mr. Katsumi, for your views. They are quite interesting. And Michelle, would you have any views on this specific topic of separate classification?
Yeah, absolutely. First, I think Mr. Katsumi, I think that's a wonderful idea to reclassify all software products into one classification, because having to deal with multiple classifications versus, as far as whether it's downloadable or non-downloadable. And now when we add into, I guess, the scope of, things to consider, the NFT and blockchain, where does that fall? Because it really, and I think it opens up the door to other questions about classification. Yeah, and in the United States, I think the current classification system, I think we can fit in virtual trademarks into the current classification system. One thing I did want to add too is that we've seen in class 35 is virtual retail services as well, where you can offer services of selling virtual goods. So that's a relevant one for brand owners looking to enter the virtual world. It'll be interesting because, as anyone who has tried to obtain registration in the United States knows, when it comes to, or when you're trying to maintain an existing registration, when it comes to establishing use in front of the United States Patent and Trademark Office, there's a lot of hurdles and they're very specific. I think it will be very interesting to see how examiners at the USPTO review specimens of use for virtual goods and for virtual trademarks. I foresee there'll be some questions and issues there. I'm thinking examples of the potential for using virtual marks, in the metaverse on street signs. Will that suffice to prove use of the mark? To show, is that going to be, for example, will that be a point of sale display when we're trying to establish that a company is using a mark in connection with virtual goods? So I think it'll be very interesting, and I think the USPTO will have to adopt quickly. Like I said, there's a proliferation of new applications involving NFTs. This is something that we're gonna be facing very soon, and I hope that the USPTO will adjust quickly to that. And I think there'll be a lot of discussions with our clients as far as how a mark will need to be used in the virtual world in order to satisfy the requirements and maintain the registration.
Perhaps we're looking at a change in our legislations.
Yeah,
what is a virtual trademark, and what are these virtual goods?
Right, exactly. Yeah. And one other thing I wanted to add too, I think the second part of the question was about the law catching up. And I think the answer to that is it's not yet. At least in the United States, we have two big cases that we're kind of keeping an eye on. There's the Nike v. StockX case, in which the StockX was offering vault NFTs featuring certain models of Nike footwear, and Nike has sued for trademark infringement. And the other case is the Hermes case, the Mason Rothschild, where there was a virtual Birkin bag being sold, and Hermes has now sued for trademark infringement. And so there's going to be a lot, there's a lot of questions there as to whether the trademark owners are going to prevail in the virtual world or use in the virtual world. So that will, these cases will certainly shape and provide guidance to us when we're looking to protect our clients' marks virtually.
So I think you'll have court-made law before you have statutory law.
Yes. Oh, absolutely. Mhm.
So yeah, Ellen, would you like to add to what Mr.
Yeah,
Watson
I
mentioned?
think the idea to have a class for virtual good is could avoid difficulties of interpretation between the goods at issue, and I think it would be yes a good idea, but actually to date we have some tools to classify this kind of good in class 9, or as already said, in class 35 or 42. So we really need to have the interpretation of the courts and the office to know how to proceed, because it's maybe too early to define a strategy of filing. But for now, I think it's wise to file new trademarks in class 9 or 32 to prevent infringements in metaverse.
Thank you, Michelle. Thank you, Ellen. I'm very sorry. So actually, the next question which I have is quite connected, and but that's something which is quite pertinent. So, do you think is there a need to register a virtual trademark if a business already holds a class setting registration? So, I already have a registration in class 9, and although it's not a downloadable product, which I'm going to get in a metaverse, for example. Let's say that if there's a separate classification tomorrow, should I really go ahead and apply for a virtual trademark in that specific class? So Ellen, we can start with you. And
in Europe, usually we recommend. We prefer to file to describe the good and not to designate head class, because of a decision of the office who state that now the goods and services are analyzed as they are according to a literal approach. So if we file a new trademarks, usually we recommend to describe exactly and not to designate a head class. So I think in the case of virtual trademark, it would be difficult to save the designation, for example, of a bag, a real bag will belonging to class 18, and the virtual bag will be considered as similar because actually they are different. So I think it would be more wise to not designate in the trademark application the head class, because it will avoid interpretation difficulties. And now this is what happens actually, because when you look at the database of the European Office, you can see, for example, trademark Nike, which has been filed in class 9 for downloadable virtual goods, namely computer programs featuring footwear, etc. The same as in the USA, I think. And actually, this trademark has been published, so it means that that's been accepted by the European Office. So this description is probably precise enough to be accepted by the office, and I think it would be better to choose to designate specific items in the application.
Thank you, Ellen. Thank you so much. And Michelle, your views on this? I believe it would be somewhat similar with Ellen, or?
Yeah, it is, because, well, in the United States, we can't use class headings. We do have to be very specific with the identification of goods and services. So that's really not an option. And I think even if you do have some sort of coverage in either, in class 9 or other classes, or for the actual product itself, this is an untested area of the law, especially with respect to enforcement, it would be best practice for brand owners to file new trademark applications for the virtual goods in order to ensure that they are able to, enter or to enforce in the metaverse, in virtual worlds. So I do think I think that's going to be best practices to file new applications.
Thank you, Michelle. Mr. Katsumi, coming to you with the same question. I
Yeah.
understand that we are yet to decide on whether we'll have a new classification concerning virtual goods. So in the interim, what is your experience before the Japanese trademark office? Do you see brands filing more with different classification, with the new classification, or with the new description?
JP has not yet discussed this topic. So I know the Nike applications in Japan, it is still pending, waiting for examination. However, as Aaron said, it is the same description computer programs for electronic products. It is yes, exactly acceptable to the JPO. However, it is not all the metaverse one. So I wanted Nike to try to specify the electronic products in class 9 electronic shoes. However, so in the current criteria it's maybe such electronic shoes is unacceptable to JPO, and so now the current JPO's criteria is only one case, and electronic publication should be similar to paper publication only. So we need to discuss more. However, if the electronic products in virtual world is not similar to real physical products, their trademark owners' benefit will not be protected. So the JPO should consider the new criteria for metaverse, new virtual trademarks, I think.
Thank you, Mr. Katsumi. So I think you, Michelle, and Ellen, I think we've agreed that it is best that brand owners proceed to file for those specific description for virtual goods and not solely rely on the class headings or the previous registrations they have to try and cover virtual goods. Thank you so much. And I think next, Shurita will have the next set of questions.
Yeah, I have the next question from Mr. Mishra. How do you think brands intend to monetize such virtual trademarks from the perspective of an IP owner?
Great question. Well, I think virtual trademarks serve multiple purposes for brand owners. The first is, I guess it's a form of monetization through consumer engagement, and it really is that it's showing your relevance to all consumers, engaging them both in the real world and the virtual world. One example is Louis Vuitton recently launched a video game that allows players, which are obviously typically the loyal brand consumers, to follow around a virtual character, Vivian, through Paris and collect NFTs, non-fungible tokens. And so these are ways that that brand owners are able to engage with their consumers, but they are also monetizing brands in the virtual world through sale of virtual goods on various gaming platforms, and through NFTs. One example is Dolce & Gabbana sold a 9-piece collection of NFTs of digital images of fashion items along with the actual goods. And NFTs sometimes are going for exorbitant amounts of money. Burberry partnered with Mythical Games, and they are selling, they're selling branded NFT accessories for use by players. So there's, and I think we're just going to continue to see a proliferation of brand owners engaging with their consumers in the virtual world, especially with when we end up seeing the metaverse. And there's so many ways that there's so many opportunities for monetization, and just thinking this through a little bit more, you have the opportunity to have virtual concerts. It's just, I think the opportunities are really endless. And I think we're just now seeing what potential there is there for brand owners. It makes sense at this point to explore and engage and, show your relevance to consumers.
Thanks, Michelle. Mr. Mishra, if I could put this question to you.
Thank you, Sarita. And what I'm about to say may gel more with the Indian audience, because my answer to your question would be SLP and M. Now, SLP for our foreign friends on the call is it signifies a special leave petition which you file in the Indian Supreme Court seeking a leave to file an appeal. But the acronym SLP in this context would be sell, license, and protect as means of monetization. And the M obviously would be marketing and advertising. Let me expand on each of those as to how it can be done. And I think Michelle has already referred to the selling part of it in terms of brands which could be marketing digital collectibles, non-fungible tokens, which could be, the consumers could buy, could collect. People in the gaming, in the game would be able to collect those. But not just those. It could also be other things. Let's say you digitally visit the Zara store and you look at the goods at the Zara store and then you select what you wish to buy, right? Again, selling. That's how you monetize your brand. Look at the McDonald's trademark application which they have filed. In the metaverse, you go to the McDonald's outlet, the virtual outlet, you select the burger and the beverage that you want. You order that, and in the requisite time, it will reach your home. This is now the virtual world and the real world coming together, right? And a great way to monetize your brand. And I'm sure that as technology develops, more and more such things will get enabled. You could have, again, digital services, etc., which could all be available. So sell is one. License is the other, which again, I think Michelle referred to as a means of monetization. And if you are playing a game, a digital game, for example, and you could have certain digital collectibles, which could actually be branded, right? For example, you could have, let's say, Nike was what Michelle referred to, I think. You could have a Coke jersey, right? Which you can collect. And the owner of the digital game would then need to enter into a licensing arrangement with Coke. That would be a means for Coke to license and then monetize its brand. The possibilities are endless and they will increase. And there comes the importance of protection. As more and more of these things happen, and as we can see, I don't see a regulated regime, a statutory regime at this point of time. And therefore will come in issues of infringement, will come in issues of fakes in this domain. And how do you tackle that? So brand owners have to be vigilant to protect their brands. Just like the other people on the panel were talking about protection of the brand through registration, the brand owners would also have to be vigilant, not just in the real world, but now also in the digital world, so that their brand doesn't get diluted. And the value that they have created in their brands, the goodwill that they have created, that doesn't get diluted, for example. And of course, marketing and advertising as a means of creation of that value. Again, in the metaverse, let's say that you come across advertisements. You will come across today on Facebook. You see advertising, right? Tomorrow, when metaverse comes in, inside the metaverse, you will see advertising as well. Those will be opportunities again for brand owners to monetize and to create value. So I think SLP and M, if I may put it that way.
That would be really useful for the brand owners attending this session. Thank you, sir. So I have a connected question, actually. I mean, Michelle, if you want to take it before Mr. Mishra. How would virtual goods or services add value to a customer experience, in your opinion?
Sorry. Again, I keep saying, I think we're just at the beginning to fully understand the answer to this question. And that a large part of it comes back to consumer engagement and making a connection with the consumers and allowing consumers to feel connected to one another. When it comes to virtual goods, one thing that comes to mind immediately is that there's going to be some sort of like kind of cachet for your avatar to be walking around the metaverse wearing, a luxury brand. Currently, in the gaming world, I think about my son who loves Fortnite and was absolutely livid with me last year when he lost it for a couple weeks, and this wasn't a monetization, but he lost the opportunity to get his Mandalorian skin for his character because he didn't have enough hours playing. And so, but for him, like it's like this, it's a status. And for in the virtual world, it's a status, is having these virtual goods. So I think that's one huge thing for consumers. Again, we talked about I talked earlier about having these virtual concerts. I was speaking with a colleague and friend of mine who had attended a virtual concert together with other friends, and that's a way of engaging consumers and participating in something that you might not otherwise be able to. And then finally, I think there's so many opportunities. I also think about the fitness world. I recently Peloton just developed a new program, and it's called Lane Break, and it is their entrance into the virtual world where you're on your bike and you're engaged in a game instead of just doing your workouts. So there's just so many opportunities for adding value to the consumer experience.
I would love to do it, honestly, be in the gym, but not do anything, just see myself on the screen doing it.
It's funny, my kids always want me to do that as my workout because they're watching me like play a video. And it's interesting. It's, you speed up and slow down and put your resistance in a different place to hit like certain targets. But, it's fun and engaging and a different way to get consumers involved.
Right. So would you like to comment on this?
Yes, I would love to comment on this because personally, I'm quite excited about the possibilities. I think this whole concept is pregnant with immense possibilities that are there. So look, let's put it in a context that today, and again, let me give you an example from my industry from which I come. In the hospitality industry, if you wish to stay in a hotel in a city, you go to the website, you look at the photographs. Today, you also have videos where you can look at what sort of a place this is. The exciting possibility which metaverse could bring is that you are actually inside the place and you are experiencing it. You're just not looking at this image on a screen or a video on a screen. You are right inside. So when, again, the example that I had given earlier, when you are selecting a banquet hall for your marriage, you are right inside the hall. You are looking at how it is, how big it is, what are the facilities, etc. What does it overlook, etc., etc. And this can go on and on. What I am talking about is a three-dimensional, intensely immersive experience that this can bring to the customer, to the consumer, to the guest. And that's irrespective of the industry. That's irrespective of the goods, irrespective of the services. Imagine, again, let me give you the Zara example, where you wish to purchase from a Zara store and you sitting in India and somebody else sitting in US together decide to visit the store, and you go together digitally into the store. And again, imagine that you have gloves which will enable you to touch and feel the fabric digitally, but you will experience what kind of a fabric you are purchasing. What is the fabric like for the garment that you will be purchasing? All of that could get enabled by this, right? And today there is a digital experience. Even today, for example, if you wish to buy luggage at home, you can experience in a way what you are buying by looking at a three-dimensional image, looking at the product from various angles. If you wish to change the colors, designs, etc., it could be, made to order. But imagine the touch and feel of the whole thing. Imagine that you are inside that environment, if I may call that. You are inside that environment to touch and feel, experience, and not just by yourself, but along with other people whom you may want. That is just amazing. That just blows the mind. So I think this intensely immense three-dimensional experience is a great value add which can come in. And therefore it's an enhanced pre-buying experience which will enable people to make better informed choices as we go forward, right? The other way in which the other value add could be friends meeting across continents. Imagine that, right? Not just everything which is commercial, business, but even social interactions, people with whom we may not have met over long periods of time. So therefore, it could make boundaries disappear. It could rekindle relationships, bring people closer. So therefore, the value add is absolutely immense. Roche, for example, has developed an application where the medical professional could actually see for himself how the drug interacts with the cellular component of the body and see for himself how the drug is acting. That's there even today. Then you have the museum, which isn't there. It's called the museum which isn't there because it exists in a digital world. Imagine the kind of value add that can bring in. Imagine that you could actually experience the pyramids without moving out of your living room. Imagine that you could be running the New York Marathon and experiencing it. You could be on your treadmill and yet you would be experiencing running the New York Marathon. That's the kind of value add which this could bring. And that's why I said this is pregnant with immense possibilities. And I'm, as a brand owner, I'm quite excited. It could take time or it could happen much faster than we think. Talking of myself, I have seen technology change so fast. It could be around the corner.
Thank you, sir. Thank you so much.
Thank you, everybody. And I think we'll now come to the question and answer session. So we have a couple of questions, and I can see a question from Mr. Srinivas Reddy. And so the first question which we have is, how different is a virtual trademark from its counterpart in the real commercial world? I think we have dealt with it, but perhaps maybe Michelle can just give a few more examples, real life examples on how they are different. So maybe dealing a bit with NFTs and how how the avatars and the metaverse buy the virtual products, how are they different from the real world.
Absolutely. Well, I mean, I guess, they certainly can coincide. The example we talked about earlier with the sale by Dolce & Gabbana of the NFT for the virtual images of the bags, as well as the physical goods themselves, that went hand in hand. But I mean, ultimately, I think they are different in that, one is physical and the other is in the virtual world, and something that you're perceiving. It also kind of it becomes important too when it comes to, again, we're guided by no real case law, no laws right now. And so as brand owners, having that protection in both the virtual world, and in the physical world becomes important, so that we can ensure that that we're able to monetize our brands in the virtual world, as well as enforce them.
Thank you so much, and I think that's a great answer. Thank you so much. We don't have any other questions at the moment, so I think I'll just request Shurita to for her closing remarks, and then I'll have shared the vote of thanks for everybody.
Thank you. Thanks to everyone. Of course, he's going to do the formal bit, but of course, as Sir said, that it's a very exciting thing coming our way. But my only concern is that, when I see a chocolate virtually and I'm unable to finally consume it, that's a real problem. So
maybe we
as
will
someone
run
just said
virtually.
that it's for Generation Z, I'm not a part of it. Or a Louis Vuitton bag virtually, no, I wouldn't want it. So yeah, but it's something which is coming a big way. So we'll have to wait and watch. As Sir also mentioned, I mean, India, we haven't seen much yet, apart from that wedding, which actually became a headlines as far as trademarks are concerned. But then we haven't seen much happening yet. So hopefully something concrete will come up soon. But thanks for this discussion. This was really useful. It was a learning session for all of us. I'm sorry for especially torturing Mr. Katsumi, because it's past 11, I guess. So you already look sleepy.
And on a Friday night.
Friday night. Yeah. And he's on a webinar. But thank you so much. Thanks to all of you. And we'll keep in touch. And if there's anything interesting happening at your end, please keep us updated. We will do the same. Thank you so much. Over to you.
Thank you.
Thank you.
Thank you, Shurita. It's my privilege to have been asked to propose a vote of thanks on this occasion. And on behalf of S. Majumdar and Company and the volunteers, I extend a very hearty vote of thanks to the panelists for joining us virtually and taking out valuable time across their busy schedules in different time zones that too, and sharing their views on this topic. Virtual trademarks and the offerings have immense potential, as I think most of our panelists agreed upon. And we are just, so as to speak, just witnessing the tip of the iceberg on how virtual trademarks can leverage the myriad possibilities in the virtual world, such as the metaverse, to connect with consumers and provide different user experiences which were unheard and unthinkable in the past. I must mention an appreciation for Ms. Shurita Majumdar for efforts in getting together the distinguished panel and co-moderating this webinar on this topic, which is quite dynamic and relevant in the current times, and especially where the digital world has permeated all our lives in the way we interact with people, businesses, brands, and their offerings. I would also like to extend my thanks to our staff members, including our IT team, for their cooperation in organizing this webinar. We've also been fortunate enough to be backed by a team of very motivated and dedicated colleagues, and I would like to extend special thanks to my colleague, Mr. Deep Dawn and Mr. Siddharth Pandey, IP lawyers, for providing their valuable support in organizing this webinar. Also, one cannot thank our attendees enough who have joined this webinar to listen to this distinguished panel. Once again, I want to state that we are almost grateful to all the speakers of this webinar. We thank you for being us today. It's been a great pleasure. Thank you very much, and have a nice weekend, all of you. Bye-bye. Bye. Bye, everyone.
Thank you.
Thank you.
My
Bye.
avatar and I wish to thank all of you.
Absolutely. Thank you. Would you like to see it once?
We should see it. We should definitely see it. Can we have a look at it?
Yeah, I think they're quite real. So, thanks to my colleague Deepro, who arranged for this.
Yeah, Deepro did it for us. So thank you, Deepro.
So I think we'll share this with all of you.
Yeah.
Thank you.
Thank you, everyone. Thank you.
Thank you. Have a nice
Thank you.
weekend. Take care.
You too.